Well, I see Judge Eisnagel is about to. There's Judge Eisnagel.
So
Okay.
am I supposed to just see one at a time? I'm so sorry.
If you look in the corner, probably the upper left-hand corner, there's something that probably says gallery view.
No. Oh, wait.
But if you don't do, Mr. Glick, if you don't do gallery view, it will focus on whoever's speaking at the time.
Okay, then can I do that, Your Honors? Is that all right?
Your choice.
Sure.
I've never done it before, so however it works, that's all I wanted to do. So,
Okay. One thing, the advantage of the gallery, though, we do have a clock, but I'll go ahead and tell you, you have 20 minutes. You obviously have no opposition. So if you want me to give you a warning in about 15 minutes, I'll do that if you intend to go that long.
that would be fine, Judge. That would be great. Thank you.
Okay, then go ahead and take up the case of McGovern versus Clark, and Mr. Glicken, you may proceed with your argument.
Yes, Your Honor. This is an appeal from a ruling from the trial court wherein the trial court entered an order dismissing the two oldest children out of 4 children. The facts of this case are that it is a same-sex marriage and the parties have been intimately involved since 2010. The first child was born in 2012, followed by 2013, and subsequent to the birth of the second oldest child in 2013, the parties got married in the state of New Hampshire. In getting married in the state of New Hampshire, one of the issues on the appeal is that the trial court failed to give and grant full faith and credit to the public action of the state of New Hampshire. The New Hampshire law, as cited in our brief, states that upon the marriage of, and it's similar to 742.091 here in Florida, that children born outside the marriage, if the parents, and it talks about husband and wife or father and mother, get married subsequently, that legitimizes those children as if they were born during the marriage. The state of New Hampshire, as I've referenced, indicates that they approach pronouns in a gender neutral fashion. So when it says male, it can mean female, father can mean mother. And as such, when the parties got married in the state of New Hampshire, at that point in time, the 2 oldest boys became legitimized as if the parties were actually married. And that's an important—
Why would we apply the law of New Hampshire when the only connection parties have to New Hampshire is they went there to get married? The kids have no connection to New Hampshire at all.
That would be correct, Your Honor, but the court would adhere to the full faith and credit clause. If someone goes to Las Vegas and gets married, the marriage is valid in the state of Florida based upon the full faith and credit clause of the U.S. Constitution. So at the point in time that the parties married, at that point, those 2 older children were legitimized, and as such, the trial court should have taken that into consideration instead of dismissing the 2 older children out of the case and leaving the 2 younger children as part of the marital estate, as I will call it. Subsequent to the marriage, the parties, of course, returned to Florida. After the marriage, the parties proceeded, the appellee proceeded to have 2 more children in the same fashion.
Counsel,
There is no—
Counsel, why don't you go ahead and maybe talk to us about the statute 742.091.
All right, sir. Yes, Your Honor. In 742.091, that statute specifically deals with children by parties where the parties were not married at the time of the birth. 742.091 reflects and deals, reflects and states that if the mother and father, reputed father, subsequently get married, then that legitimizes the children that were born prior to the marriage as if they were born during the marriage itself. And so the issue that we have brought up on appeal based upon Judge App's decision was he had ruled that 742 It deals with reputed fathers and mothers. It does not approach it from a gender neutral standpoint. And Judge App talked about the reputed father being a biological father and that the connection between the child or children has to be biological. Our position is that is not what the statute says, and that is not what should have been ruled. As a result of my client, and it's a same-sex marriage valid, the court should have, with all due respect, accepted 742.091 and adhered and allowed it to apply to my client. It does not just deal with biology, it legitimizes the children and it deals with the best interests of said children. So when the court dismissed the...
Let me stop you for just a minute and ask you, I mean, the statute has two key words, it seems to me, reputed and father. And I know that Judge Evander wrote a case a couple of years ago that had a bunch of initials. I don't remember the exact initials, that said, basically, the statute doesn't say biological father, it says reputed father, which may or may not be the biological father.
Yes, sir.
So I'm somewhat sympathetic to your argument that biology isn't necessarily the test. But how can you get where you want to be? You want the statute read in a gender neutral fashion. In other words, you're making essentially an equal protection argument.
Yes, sir.
But you haven't challenged the constitutionality of the statute. And if you did, both the statutes and the rules require that you give notice to the state attorney and or the attorney general before you can challenge a statute. So
Yes,
how
sir.
can we say that the statute has to be read in a gender neutral fashion if you haven't joined the required parties below?
Your Honor, it's from the standpoint of being gender neutral that the cases and the law is constantly evolving as it pertains to marriage. And we've referenced that as far as the brief is concerned in dealing with previously, it was illegal to have interracial marriages. Previously, the wife was the property of the husband. And this keeps evolving. When the Supreme Court rendered, the US Supreme Court rendered decision of Obergefell, at that point in time, the Supreme Court stated that basically sometimes decisions needed to be made and you couldn't wait upon the democratic process because it was such an important, vital issue. In this particular case, because of the 4 children, it's a quandary. There is no doubt about that. We have 4 children, all 1 year apart, and based upon the fact that if the parties were married, and my client should be treated the same as any man, as should be the appellee in seeing 742.091, from that standpoint, it basically discriminates against my client and does not.
Well, I think what
sorry.
Judge Orfinger is essentially asking you is, can you prevail without challenging the constitutionality of the statute as it is currently written?
If the trial court stated that Judge App was very clear from the standpoint that he was not going to address the constitutionality, he was, as a trial court, had to look at the statute and follow the dicta of the statute, and that it was based upon, in the future, either the legislature changing or an appellate court making a ruling. This particular case, I believe the court should approach it from a gender neutral standpoint. That is the fair result, because we have to look at what's in the best interest of the children and what will end up occurring if this order of the lower court dismissing the 2 older children remains in effect. It's just the results of it will just be catastrophic. You will have 2 older boys currently. I'm sorry, Judge.
Let me just stop you for a minute.
Yes, sir.
Again, the statute has 2 key words, reputed and father. I'm sympathetic to your argument on reputed, but the only way you win is you have to make the argument that father denies your client equal protection, that it has to be read in a gender neutral fashion, or it denies her equal protection of the law.
Yes, sir.
And my concern is that you may well be right, but you haven't directly challenged the constitutionality of the statute, and you haven't joined the state as required by section 86.091 and rule 1.071 that say, if you're going to challenge the constitutionality of a statute, you've got to give notice to the attorney general or the state attorney, so that the state whose statute's being challenged has a, they get invited to the party.
Yes, sir. If we look, and again, the statute originally, if we looked at the marital statute in the state of Florida, where it said man and a woman, when Obergefell came forward from the US Supreme Court, at that point in time, it changed the dynamics of everything. And I don't know that, although the term reputed father is utilized, I don't know that there is the Florida statutes don't define anywhere that I found what a reputed father is. And it doesn't require, the statute doesn't require that the reputed father be the biological father of a minor child born out of wedlock.
Counsel,
Mr.
I'm sorry.
Glicken,
Yes. Yes.
assuming, did the trial judge even get to the constitutional issue, or did he say because there's no biological connection, you can't meet the statute anyway?
He ruled that there was no biological connection. That's how he approached it. And respectfully, I understood his position, but I believe it's incorrect.
Now, he also ruled that he lacked jurisdiction over the children.
Yes, the two oldest children, Your Honor.
Is this a subject matter jurisdiction issue, or is this a standing issue on your client's ability to address the custody of the children, or does the judge have jurisdiction to say, I find that, that your client is not a parent of these children? Or it's kind of, he went on a jurisdictional route, and I'm trying to determine if that's the correct way to have addressed this or not.
From the standpoint of this particular case, he based it upon, in my opinion, Your Honor, biology. And they're obviously in a same-sex marriage, and it would be impossible for two persons of the same sex to, have children. They would either have to go, one is going to be a natural biological parent and the other is not. But the judge ruled that it was a biological parent, or yes, the biological parent. And since my client could not be the biological parent, then there would be no way ever for her to satisfy the requirement of 742-091. And if our approach, or the approach to this specific case, was that once they got married, even though it was in New Hampshire, it legitimized the two older children. The law is the same in the state of Florida. And so from the standpoint to say that simply because my client is not biologically related to the two older boys, and therefore they are not part and parcel of this dissolution, it deprives her and the children. It abandons common sense. And in looking at the four kids, you're taking two away and saying, this woman who's been your mother for 7 and 8 years respectively, she no longer exists. And your two brothers that you have had that are 2 years younger, 5 and 6, they're no longer your brothers. And so the quagmire that opens up as a result of this, I mean, the harm is going to be irreparable to the children. And I believe that the cases reference utilizing common sense and what is in the best interest of the children. And it clearly would not be to deny her the ability to avail herself of 742-091.
Counsel, I guess what I'm not sure I've gotten a clear answer to yet is, it seems that you make a constitutional argument in your brief.
Yes, sir.
Specifically due process and equal protection. You expressly make that argument. And I guess all we're trying to get to is that it doesn't look like the constitutionality of the statute is properly before this court yet, because the trial court has not yet ruled on the constitutionality, and because the procedures for bringing in the state have not yet occurred below. Do you agree with that?
I agree. The trial court, Judge App made it clear he was not going to address the constitutionality of any of the statutes.
So do you
And
agree
he
that
said-
so would you agree also then that the constitutionality of the statute is not properly before us?
I don't know necessarily, Judge, if, Your Honor, if it is a gender neutral approach to the statute, the statute would be in fact constitutional. And so from the standpoint of, saying father and, versus mother, or, man versus woman, if the court approaches, as other states have done in taking a gender neutral approach to these types of pronouns, then the statute would in fact be constitutional. So our argument is that you look at the statute and you look at it in a gender neutral fashion. Not that it's unconstitutional, but it's that you don't have to be biologically connected to the children or child at issue, and that the reputed father, again, I did not
Well,
find the
Mr.
definition.
Mr.
And
Glicken,
yes, I'm sorry.
I
Yes,
think there's a difference between the question or the issue of biological connection and the issue of the constitutionality of the statute or the interpretation of the statute regarding whether it should be gender neutral or not. So if we agree with you that the trial judge incorrectly determined that a biological connection was required, shouldn't the trial judge then have the first opportunity to address how the statute should be interpreted, or whether it's unconstitutional as applied, et cetera?
well, we did attempt to, and we argued this position before the trial court and before Judge Apt, in arguing that biology was not the
Okay, you're
standard
missing
to
the,
utilize.
you
I'm sorry.
you keep going back to there's two issues I would submit.
Yes,
There's
sir.
as Judge Orfinger used the word, reputed and father, two separate words. Reputed, what does reputed mean, even if you have a male and female? And the trial judge seemed to suggest that had to be a biological connection regardless of the gender. And then you have the second issue of the gender neutrality, if you would. So we're trying to divide it into two issues, and you keep
I'm
kind of lumping them together.
Okay, and I'm sorry, Your Honor. From the standpoint of the reputed aspect, it would be one who holds themselves out as the parent. My client, clearly the facts established, the brief establishes that she in fact has done so. They have her last name. The two older boys are what we're concerned about. So from the standpoint of her being a reputed parent, she would be. The term father should be looked at in a from a gender neutral standpoint. And so she would in fact should be considered under 742-091. And the second point of being the gender neutral aspect of it, that's what we believe is the fair and equitable approach to this specific case.
Counsel, I guess the question or the point we're trying to get to here is that on the second issue, on the gender neutrality, seems to be a constitutional issue. It's based upon your due process and equal protection arguments. And that doesn't seem to be properly before us because the trial judge did not rule on that issue. And the procedures weren't yet followed below. So I guess the question I have for you is this: if this court agrees with you on the interpretation of the statute, that there is no biological connection needed, and there's certainly case law supporting that argument, what should we do? Does that mean that, but we also conclude that we can't reach the constitutional issue because it's not properly before us. Does that mean you lose, or should we send it back to the trial court reversing its ruling on the biological connection and us not reaching the constitutional issue since it was not ruled on below.
All right, Mr. Glicken, you have a minute to go, so please go ahead and answer that question. Then you'll be down to near the end of your time.
Yes, Your Honor. Reversing, Your Honor, would be the request that we have remanding back to the trial court based upon the fact that he utilized or relied upon the biological aspect, which is not necessary. And that's what we would request.
Okay, thank you. Anything further?
No, sir, Your Honors. Thank you so much for allowing me
Any
to
other
do
questions
this.
from the panel?
Nope.
All right, this concludes the oral argument session for this morning. Thank you all.
All right, thank you.